Right. Well, hopefully you're able to get your head around the principles of the British Constitution. That was kind of complicated. This one is an awful lot more straightforward. As I said last time, we have these basic sources of the Constitution, and the general idea here is that between the five of those, we reify, we give shape or form to the principles of the Constitution. So you'll remember that the principles of the Constitution are held to have emerged rather unhelpfully from the mists of time. We need to have some sort of practical application of those principles, and we do that through our sources. So I don't know what that's doing there, and I can't get rid of it. Never mind. So statute law. This is very, very simple. You'll remember from the supremacy of Parliament, parliamentary sovereignty, that what we've got here is statute law, the highest form of law in the land. This is a law passed by Parliament, enforceable in the courts. Here are a few examples. We're going to have lots of them coming up, and this kind of dates the initial presentation. There are lots more, and I'll give you lots of examples of these. Don't worry. So, a statute law is a bill that has entered Parliament, has been signed off by Parliament, and then has been imposed or promulgated by the executive. Common law, however, is the courts filling in the gaps between statute laws, if you like. Where there is no statute law, where there is no clear law, the courts have the opportunity to go in and fill in the gaps, and the decisions of the courts are held to be binding in cases of a similar nature in the future. Note that the royal prerogative is an example of common law. That's one of the easiest ways to remember it, and we'll spend a lot of time looking at the royal prerogative later. But the idea here is that these are precedents. If there's no clear bit of guidance from the statute law, the courts have the ability to make a decision, and then that decision is considered legally binding in future dates. Of course, until such time as Parliament decides enough of this and we're going to create our own law. And that's exactly what happened with the Human Rights Act. Prior to the passage of the Human Rights Act in '98, most of the civil liberties we know and love were described entirely in common law. And it was said we don't need a Rights Act because they're written down in law. So they are established in common law. No, said the Blair administration, we need a Human Rights Act. So they introduced the Human Rights Bill to Parliament. Parliament looked at it, decided it was good, and then created the Human Rights Act, a statute law. And at that point, that trumped all of the many, many hundreds of years of common law tradition that upheld our most basic rights. So that's common law. Constitutional convention. Constitutional practices established through protocol, blah, 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 blah. In other words, we used to do it that way, we're always going to do it as follows. These are procedural rules, and everyone is supposed to abide by them. The point here, and this is perhaps one of the most important things, is that they are not legally enforceable, and that's really very, very important. Constitutional conventions, here are some examples. The ones that everyone seems to remember generally are the Salisbury Convention, which actually isn't in this particular... Oh, there it is there. So the Salisbury Convention, which sits at the bottom, down there. Again, this basically says that the House of Lords should not veto legislation that was based on a government manifesto or the successful party's manifesto. But we've got all of these various different examples of constitutional convention. Finally, works of authority. These are writers who just happen to be in the right place at the right time. You only need to know that they exist, and there are the three main ones. One that may be adopted in due course is Constitutional Theory by Geoffrey Marshall, but I haven't seen that referred to as yet, but we'll watch that space. Finally, treaties and laws of the EU, and again we looked at this when we were looking at the EU. The idea being that the European Communities Act gives primacy to EU law over UK law, but that's only as long as we play by the game. So that was established in the first instance by this. It was then reinforced by that, and reinforced by that, and we've had several others since then. So those really are the sources of the Constitution. You need to know them before we can start thinking about how we might evaluate it. But I think we're all agreed that after a fairly punishing discourse through the principles, 5 minutes on sources is really pretty easy. Speak to you in class.